Welcome guys. This is going to be part 2 for Area Study 1, Unit 1, Legal Foundations. So in this video, just to remind you once again, remember for the SAC, you're going to need to have a pretty good understanding of these 8 key areas. But what we're going to be looking at in the video today is the roles of Parliament and courts and what they sort of do. And the most important part from this key knowledge area is their relationship between each other. And then we're going to look at this key word, which is known as sources of law, or also known as where laws come from. And that is common law or court-made law, and statute law, which is parliament-made law. So just to recap, particularly for this key knowledge area, the key sort of task that I want to sort of explore this video is what's known as explain. So when we are explaining something, we're considering the what of a concept, so usually the definition, how it's relevant, and why it's particularly relevant. So I'll go through an example when we go to the relationship part of this this video here. But just like I said, really want to stress this once again. These task words, if you understand them now and you know what each of these task words are asking for you, it's going to make answering these SAC questions nice and easy. So first of all, just to start off with our federal parliament in Australia, what's really important to know is it's made up of this structure here. So we have a lower house known as the House of Representatives that has 151 people in it. We have the upper house known as the Senate, which has 76 members in it. And lastly, we have our King's Representative, or what's known as our Governor General. So while we're looking at this sort of structure is we're going to sort of learn how a bill becomes an act of parliament, or how a proposed law becomes a physical law. So what we're going to first look at is what's known as the lower house. So this is the house that has 151 seats. So the lower house is where we form government. And how government is formed is from those 151 seats, the party that holds the majority of those seats, so at the time of this video, that is the Labor Party, they form government. And they are the ones who sort of are in control of the lower house and have most power in terms of passing new bills. So the number one role of the House of Representatives is they help to form government. It's where the Prime Minister sits and many other key figures in our Parliament. The second one is that they need to represent the people. So how Parliament represents people is that they are actually voted in. So there's 151 electorates in Australia, and basically what they need to do to get their position of power is they need to be voted in. So everyone above the age of 18 is required to legally vote so that we can ensure that we're getting a widespread majority of our views and values being represented. And probably another really key one to look at here for both the houses we're going to look at in today's video, the whole reason Parliament is there and the reason they sit that there's 100 days a year in Parliament is they're there to introduce and pass new laws as required. So like I mentioned in that last video with cyberbullying, they might see that the bullying laws are really outdated, so they're going to introduce new laws to help reflect our current day situation and introduce things like cyberbullying. When we bounce on over to the upper house, which is known as the Senate, it is the house that generally is responsible for reviewing bills. So what we might think about here is that we introduce a new potential law in relation to cyberbullying. It passes through the lower house, and what the Senate is they're going to do is they're going to heavily review this bill, fix up any errors in the bill, improve it as best as possible to make sure it's ready to go on to its final stage before it becomes a law. So they're going to really heavily scrutinize all the bills that are presented to them. Secondly, it ensures equal representation of the states. We want to make sure we get widespread values represented, so we make sure we have enough members from each state and territory representing the views of Australia. And lastly, nice and straightforward, is that they introduce and pass bills. So pretty straightforward for those two there. Moving on to the role of the courts, what I want you to remember is that the primary reason we have courts is to resolve disputes. They're primarily there to hear cases and then decide a verdict or decide a remedy if it's civil law. But what they can also do is they can also make laws. So if there's no existing law, or if a law is sort of unclear, they can go into the process of making law through what's known as statutory interpretation. and they can also make law by deciding on a new issue. So let's just say a case comes to court that has never been heard before. They can help make it that error fixed up by making the law as required. So to give you an example of what courts might do, you may have looked at this in class, is what's known as the studded belt case. So it's a case that is well known for what's known as statutory interpretation. And basically the gist of it is that a guy or a gentleman went into McDonald's and he was wearing a black leather belt with raised silver studs. And obviously that sort of item here, he's using it to hold up his pants. He wasn't using as a weapon. And then basically he got arrested and had his belt confiscated and was told he was guilty of the crime of possessing a weapon. And what he did is he appealed that case and the confiscation of his belt. And I guess what the courts were able to do is they were able to determine that anything that is not in common use for any other purpose but a weapon can't be deemed a weapon. So what they found for this particular individual is he couldn't be found guilty of carrying a regulated weapon when he was basically just using it to hold up his pants. So why this case is really important and it represents statutory interpretation is it allowed the definition of a regulated weapon to be removed from the Controlled Weapons Act. So it cleared up an area that was a bit grey, is essentially the best way to put it. So basically previously, if you were walking around with a studded belt just to hold up your pants, you could be arrested as they deemed it a weapon. But now after this statutory interpretation process, they made sure that you cannot be charged for that particular crime. So for this particular point here, we need to know the 4 ways in which courts and parliaments work together in order to process the challenges that they face on an every day-to-day basis. So going from the first one here. So the first one you're going to look at is what's known as codification. So what codification means is that courts might make a decision that they believe that they need to make a change in a particular area of law. And when courts make that decision, Parliament steps in and says, hey, we really agree with that decision you made. And what we want to do to make it really strong is we want to turn that common law or that court-made law you just made into statute law. So courts make a decision, Parliament really agrees with that decision. They want to really, the key word here is they want to strengthen that area of law. And how they do that is they make it into a statute law. So it's called codification, or sort of confirming the decision of the courts. Example you probably will look at later in Year 11 is what's known as the Mabo case. And they overturned a term known as terra nullius, which means no man's land, and developed what's known as the Native Title Act. So originally Australia was considered no man's land, so anyone could inhabit it. And after this High Court case, Parliament stepped in and created the Native Title Act to make the law decided by the court a lot stronger. When we flip to the other side, which is abrogation, this is when pretty much the exact opposite. It's when Parliament disagrees with common law. And what I mean by that is courts have made a decision. Parliament says, we don't really agree with that. So what they want to do is they take action to rectify this. So they really don't agree with the decision that a court made in relation to a particular case, and they go out of their way to change or rectify or fix the problem. So you can look up this case. It's a really famous case, the Trigwell case. Basically, the High Court chose to follow a really outdated law from England that meant that stock owners, that meant that farmers weren't liable or responsible for their cattle. And what Parliament did, because they really disagreed, is they decided to abrogate this really outdated law and basically establish a law that made stock owners liable for damage to their stock caused. So if you look up this case here, you'll get a little bit more details. But basically, prior to this decision, farmers weren't responsible if their sheep, for example, ran onto the road and caused an accident. But after this case, it's now your responsibility to ensure your animals like sheep are fenced away so they don't cause any harm to the community. So moving on to our second last 2 features of the relationship is the ability of courts to influence decisions. So basically at the end of a court case, they might make a comment that they want to sort of stress that a parliament should make a change. So they might make the decision to their case, and in making their decision, they make a few comments that is hopefully prompting parliament to make some change or sort of influence parliaments to make some change. And the last one we just talked about is at the start, is about that stutter belt case, is statutory interpretation. So when words in laws are really unclear or they just don't make a whole lot of sense, what courts can do is they can give meaning to words through their judgments. So if they're saying that the definition of weapon is really unclear, they can interpret that law and give a lot of meaning to that law to make it easier to understand and help resolve the case. Okay, so that's that key knowledge area done. Moving on to sources of law. This is one where a lot of students get very, very confused, but it's very straightforward to break down. So what I want you to think about, whenever you see source of law, it basically means where do laws come from in Australia. So if I'm asking you the source of something, where does it come from? What was the source of this food? What was the source of this movie? Where did that particular thing come from? So in Australia, you need to remember that we have two main sources of law. The first one is statute law or parliament-made law, and the next one is common law or laws made by courts, like we just mentioned in that last couple slides. So first of all, statute law is basically what we want to think about is that statute law is laws made by parliament, and they get made by parliament as sort of there is demand or pressures from groups from members of society. So a really popular one in the news right now is the use of vapes. There's a lot of pressure to make vapes a lot more harder to obtain, needing a prescription to use certain types of nicotine vapes. So how a statute law comes into play is generally we get a lot of pressure from a particular group or a petition or something like that, and then it gets introduced into Parliament. Once it gets introduced to Parliament, it goes through a couple stages. So the first one is going to be initiated and read for the first time. So it'll be read usually, not always, but in the lower house first, and they're going to go through each of the bills. They're going to go through the bill and discuss it briefly. It's next going to be read for a second time, and they're going to really start to deep dive into things like the function of their proposed bill and the purpose of their proposed bill. Next, it's going to go through what's known as the third reading. So this is where they're going to really start to break down that bill. They might make adjustments or changes to the bill, and they're going to vote on it as to whether they think it should be passed into the next house for its next stage. So when we look at the upper house, it follows the exact same process. So say for example, it starts in the House of Representatives and goes to the Senate. It's going to go through those three readings in detail. And like I said in that earlier slide before, the Senate is usually scrutinizing or reviewing that bill in detail and pulling out any errors. And then the last stage for a bill to become what's known as an Act of Parliament or statute law is it goes to the Governor General, who is, like I said at the start of that video, the King's representative, and they give it royal assent. And once it gives royal assent, that's like that last stage or tick of approval, and then it officially becomes a law. Okay, so to give you an idea about some practice questions here, what I've popped on here are two examples of both an act and a bill. And like I mentioned before, is when you see the source of law, it's asking you where it came from. So when we look at here, this Crimes Act 1958, we can tell that it's a statute law because it's an act of Parliament. And another giveaway for us is that this one was made in the Victorian Parliament. So if it said Crimes Act New South Wales, we'd know that it was a Parliament-made law, but it was made by the New South Wales Parliament. If we look at this next one here, it's the Disability Amendment Bill. This is a proposed law. We can see that because it's a bill, it's a Parliament-made law, and we can also tell by these brackets here that it was made in Victoria. All right, moving on to common law. Identifying the source of common law can be a little bit easier sometimes because generally what we can see here is they'll all have this little court identifier number. So whenever you see that little number down the bottom there, you generally know it was in, say, the County Court or the Supreme Court. And another giveaway is generally there's going to be two parties versing each other. So if there's common law, it might be DPP versus Styles. So we can see that that would be an example of a common law. So I guess my advice is don't get confused. Whenever you see the word source, just think, where do you think that particular law has come from? All right, moving on to the second type of law, it's what's known as common law. So common law is basically known as case law, and it's how judges make law to resolve cases. So judges are not always going to make laws. They're only generally going to make law as the need arises or if they're filling an existing gap. Because just remember, their primary role is to just resolve disputes. And they make their laws by decisions made by judges in court. And like I said, we've talked about the statutory interpretation and also precedent a little bit. So to give you an idea how judges make law, they make laws through two main ways. The first way they make law is what's known as the ratio decidendi, and that's basically the decision or the rationale for their decision. That's the first way they can make law. Another one we can see that they make law is what's known as statutory interpretation. So it's basically when judges give meaning to words. So let's just say we've got an act of parliament that is super confusing. The judge steps in and says, yep, this is really unclear. I'm going to interpret the words in this act to make it easier to understand and resolve that case. So just like the Statute case, they interpreted the word weapon or regulated weapon to give it meaning to help resolve the case. Almost there. I know it's a long video. The last two slides is basically the doctrine of precedent. And why the doctrine of precedent is very, very important is because it basically means we can always generally predict the outcome of a case. The reason we can predict the outcome of most cases in Australia is that cases that have similar issues will follow the precedent of previous cases. So what that means, for example, is if there are all these cases in the past relating to assault, all future cases of assault will use those previous precedents to help make their outcome. So they might say the average punishment handed down for assault was 12 years. This case is very similar to the last case I have. I'm going to hand down 11 years. I'm going to hand on 13 years based on the situation. So the doctrine of precedent is basically in place so that judges have a guideline to help make the decisions. But just remember, if there's no cases that are the same, that's when judges really need to step in and make law as required. So I know it's been a long video, but just to finish up with two key concluding points, we just want to remember we have our two roles of the houses, two sets of houses, sorry. And just think, if you get confused, the main reason Parliament is there is to make laws, but they also do some important things like form our government and that sort of thing. Secondly, don't forget, whenever you see what is the source of law or identify the source of law, remember that's just where something came from. And if you're ever asked in a SAC, what is the source of a law, just always assume it's got to be either common law, so a court-made law, or it's got to be statute law. So hopefully that's helpful, and I'll see you guys in part 3.